Hello, and welcome to this first episode in a new series called SRA for HR. This series is aimed at highlighting and maybe demystifying some of the key aspects of SRA regulation that are really relevant for HR professionals in law firms. They're going to be short and punchy, they're going to be high level, but hopefully will give you a bit of an overview of some of the topical important issues that the SRA are considering from a workplace scenario. I'm really delighted to be joined by Andrew Pavlovic, who heads our regulatory unit and specialises in SRA regulation and professional discipline issues. Hi, Andrew.
Hi.
Can you just tell us briefly why it is important for HR professionals within law firms to have a decent grasp of SRA regulation and how it applies to the firm and also to individuals within it?
Yeah, well, firstly, as individuals, they are subject to the SRA principles, as are any employee. But in terms of HR specifically, I think we've seen an increased regulatory focus on non-financial misconduct in the last 5-6 years, really coming from the Me Too movement initially, and the focus on sexual misconduct and sexual harassment. And then more recently, the SRA's focus on workplace environments, bullying, harassment, etc. So I think before we might have had quite a clear dividing line when something happens in a firm, that's a risk and compliance issue or that's a HR issue. And I think those lines are becoming more blurred. And as you said in your intro, I think HR need to have at least an understanding, even if they don't need to be experts, but they need to have an understanding as to, okay, this could also be a regulatory issue, which I need to inform my colleagues in risk and compliance about. So I think that's the main reason, this sort of increased focus by the SRA on non-financial misconduct in various forms.
So I guess the first top tip out of this is for HR to be very closely aligned with the CULP and the compliance team in a way probably that they haven't been previously, kind of to have the CULP on speed dial and to be having sort of regular conversations about what is happening within the HR environment that could potentially sort of raise a flag on the regulatory side.
Absolutely, yeah.
So for HR professionals in law firms out there who just want to get their arms around, I guess, some of the most important documents and the most important principles, maybe a little bedtime reading, I guess what are maybe the 2 or 3 perhaps most accessible and interesting documents that, would be useful for them to reach for in the first place?
Yep, I would start with the guidance on workplace environments, which we're going to be covering a little bit today, because that talks about how the SRA assess and deal with complaints of unfair treatment. You've also got guidance on sexual misconduct, which is a few years old now, but it remains very relevant, sadly. And then finally, I would probably reference the guidance on internal investigations, which was published around a year ago, because that sets out best practice from a law firm perspective and how to deal with allegations of misconduct when they're made.
Brilliant, thank you. And what we'll probably do is include links to those 3 documents with this recording, so that if anybody can just click through and have a read. I'd say they are quite practical, I think, as well as being relatively clear on the rules themselves. Let's talk about unfair treatment. So a lot of our viewers will be really familiar with this because there was a lot of coverage about it when it first came in. I think in practice, we're maybe seeing sort of proactive engagement with it dropping. And I just wonder if you could maybe give us an overview on the obligations on firms and also the obligations on individuals, particularly managers, stroke partners, in terms of unfair treatment and obviously preventing it.
Yeah, so the rules came in April 2023, as you said, and there was a lot of publicity and guidance at the time, but I think it is worth a refresher. So the Code of Conduct rules in the Code for Individuals provide that individuals must treat colleagues fairly and with respect. They must not bully, harass, discriminate or against them. And then if for managers, which is partners in a traditional law firm, they have a duty to challenge behaviour that doesn't meet that standard. So to step in or intervene, either in the moment or after events, take action to deal with unfair behaviour. And then there's a similar obligation in the code of conduct for firms, but that code requires that all employees meet the standard. So all employees need to be made aware of the rules so that they do not fall foul of it. It's been around for 2.5 years now, as you say, and I think interest has perhaps dwindled slightly. There was a lot of good practice, I think, when the rules first came in. We did lots of training, and we had the guidance, which was published in May 2023. And we haven't seen much in terms of cases coming through in the tribunal, and maybe that's one of the reasons why the interest has dwindled. But it is still very relevant, and it's still something that HR teams need to be fully aware of.
So I guess what would be typical examples in practice that we would see, that you would see, of these of behaviours that would fall within these type of rules?
Yeah, so the SRA were at pains to stress that they're not trying to create a quasi-employment tribunal. So that their sort of definitions differ slightly from the employment context or the Equality Act context. So, for example, when they talk about harassment, you have a purposive or effect test in an employment context. Whereas if you look at the SRA guidance, they're sort of concentrated on intentional behaviour, a behaviour that someone looking at it would say that was intended to bully, harass, or belittle.
Which is a really significant difference.
It is a significant difference, yes. And also in terms of bullying and sort of creating sort of a toxic work environment is where these rules came from. So what they're concerned about really are the sorts of behaviours that could lead to an individual doing something unethical, such as, covering up a mistake on a file because they're worried that if they were to admit to it, they would be shouted at or subject to unfair treatment. So they've tried to create a sort of a dividing line between which was relevant from an employment perspective and what's relevant from a regulatory perspective. And in reality, we are still being asked regularly to advise, where a finding of bullying or harassment has been made, but following an investigation or even at the outset of an investigation, is this reportable? And it has become relatively easier as we've got more familiar with the rules to determine actually these elements which the SRA say are important, for example, intentional behaviour or behaviour which amounts to an abusive position or subjecting people to unfair treatment because of a particular characteristic or a vulnerability. Those are the sorts of things they take seriously. And we're able to distinguish between employment sort of issues or employment findings and regulatory findings. So over time, I think it has become a bit more straightforward, and that sort of concern hasn't really come to pass that we were going to be creating a sort of separate employment tribunal.
And it's really interesting in their guidance, they do make it clear, the SRA makes it clear, what we're not trying to do here, or what we don't do is provide remedies for individuals. What we do is look at breaches of the regulations and take action where we find it, as you say, where it's serious enough abuse of seniority, etc. So that's really interesting. And what I also find really interesting is that so it will cover the broad range of breaches of discrimination and bullying, although there's the aspect of intent. But actually, it will also, the SRA don't feel constrained by the Equality Act, but by the it being a protected characteristic or not. And I just wonder if you can talk to us a little bit about what could fall outside protected characteristics, but still fall within the SRA's remit here.
Yeah, so this comes from the updated guidance on equality, diversity, inclusion, which they published in September of this year. And it hasn't actually received that much attention, but there's quite a lot of interesting stuff in there. And they provide some further examples of cases which they say could amount to unfair treatment and may need to be investigated under their rules. And as you say, that they make clear in that guidance that they're not constrained by the Equality Act protected characteristics. And they give an example of someone being overlooked for client work or not being selected to work for a particular client because they went to a state school and they have a regional accent. And the firm don't think that they would be suitable for a particular client. And apparently in this hypothetical case study, some sort of rather unflattering comments were made as well. And they said that, and that's the sort of case where they may take action even though social class is not a protected characteristic.
I mean, I find that interesting. I'm obviously a girl from the Northeast. I was once described as sounding like Cheryl Cole, and I do wonder if, in the course of my career, maybe I wasn't put in front of certain clients because I didn't have the right voice. But anyway, so it's really interesting that the SRA have identified that as, a potential exclusionary behaviour, pattern of behaviour that could result in a regulatory issue, particularly if it's serious enough. So just going back to, the principle about kind of treating colleagues fairly, and that, one of the SRA's overriding objectives here is to ensure that, the delivery of legal services is upheld in the public interest and is protected. And I'm interested in the definition of, fair treatment of colleagues. Now, obviously, in the supply chain of law, there are a lot of different colleagues. And my understanding is that it doesn't just mean the person sitting next to you within the firm, but can actually have a far wider reach in terms of the obligation on the firm and on the individual to ensure fair treatment of colleagues. Can you just talk to us a little bit about that?
Yep. So the guidance does make clear that they're not just concerned with the sort of fellow employees. They will look at contractors of the firm, such as consultants, experts, and barristers. One of the cases in the case studies for Principle 6 guidance I just mentioned involved a firm that decided not to instruct a barrister because the client said they didn't want a female barrister working on the case, for example. So it does extend beyond just your colleagues in a work setting and can extend to third parties.
So just to ask you, in that case then, if the female barrister who thought she was otherwise might have been selected for this job, somehow she knew about it, she found out that she wasn't selected because she was a woman. So what would happen in that scenario? Like, who would be reporting that? What would you expect to happen?
Yeah, I mean, it's a good question in terms of how it would come to the SRA's attention in the first place. But if it did, perhaps through a file review or something like that, and someone looking at it and saying, no, this wasn't right, and the firm self-reported it, then the SRA could take action against the firm for discriminating effectively against that person by not instructing them and following the client's instructions, which were themselves discriminatory.
And then the individual themselves, who was the one who made the decision, the frontline decision, presumably they would have an individual reporting responsibility as well.
Yeah, exactly.
Okay, interesting. And we are actually seeing cases where the third parties, whether it's an in-house counsel who's been somehow affected or seen someone affected, or another external person is actually the one who's brought it to the firm's attention, and then the firm has to deal with it, or they've actually made the report to the SRA themselves, and then it's been flagged with the firm, which is slightly worse because you've not got ahead of it yourself as the firm or the individual.
Yeah, that's always a dangerous position to be in, because sometimes the SRA won't provide you with the report either, so that you won't know exactly what that person has said. So that can be a tricky position, and certainly not one that you want to be in, because, as you say, you want to be able to show that you've reflected and you've self-reported a matter yourself. Can
we just talk about the obligation to challenge? And how that, I guess, a reminder as to what the requirement is, what the SRA rules say, and what we're seeing in practice. Now, what I can say personally is that it's very nuanced. It depends in practice on the situation you're in. But certainly I've been in situations where I've been at events and I felt that someone else in the profession who I felt maybe is just behaving in a slightly inappropriate way. I've sort of I've kind of interposed myself between them and the subject of their attention to give that person the opportunity to move away and to engage with the individual myself, just to distract them. They weren't very happy, let me just say. And I've also said, dude, you just crossed the line.
Mm.
And people receive it in different ways. Not everybody welcomes it. Some people realize what's going on and maybe appreciate. But I think there's a sense of empowerment that these rules actually give you, that you do need to do something. So yes, apologies. Can you just remind us what the requirement is, how the SRA expresses it, and what we're seeing in practice?
Yeah, so the requirement is to challenge behaviour that doesn't meet the standard. And then the guidance isn't actually that helpful because they say they don't prescribe how you should do it, but it must be effective. And they also say that, if it is serious behaviour, serious misconduct, then the obligation to challenge arises in the moment. So I think you've got a decision to make, and you're seeing this play out. Is it something I need to challenge now? Is it something that I can challenge after the event by either speaking to that individual or reporting it to HR or the COLP or whatever your reporting lines are? And then how do you challenge it as well? Because as you mentioned, sometimes going in and making a comment, it could inflame the situation or it could escalate the situation. Maybe the better thing to do in the moment is to try and diffuse the issue, take someone out of the environment. That wouldn't extinguish the obligation to challenge it, but it would at least ensure that it didn't go any further in the moment.
Mm-hmm.
So sort of diffuse it in the moment and challenge after the event would
And
be.
then you talked about reporting and also recording as well. So can you just give us a little bit more guidance on that?
Yeah, so this is actually probably been one of the most contentious bits of the guidance to grapple with because it says every time you challenge, you should consider how you're going to record that.
Hmm.
And that sort of cuts across the sort of the spirit of the guidance. And certainly when we spoke to Julia Oliver when she was at the SRA before, she said, no, it's not about, writing up lots of challenges and registers of challenges. It's more of a sort of a culture, creating the right culture in the firm and partners being able to sort of pull each other to one side and say, that's not on, don't do that again.
Mhm.
So that's the sort of the intention behind it. But then you've got this section in the guidance which says every time you challenge, you should think about how it's going to be recorded and what the follow-up action is. So there's a bit of a tension there.
Mhm.
And I think it does potentially detract or make people less likely to challenge if they think, okay, that behavior was on the line. I'm not going to challenge it because maybe I'm now going to have to go and report it to someone, and it becomes much more of a formal thing than it would have been otherwise. So I think
But
that's something that people have had to grapple with really in terms of how do we record it, where do we record it. There's all the usual sort of DSAR sort of considerations, which
yeah,
probably won't want to get into for the purposes of this talk. But actually, the whole challenging and recording aspect is probably the most difficult to grapple with.
the one thing that this obligation to challenge um, should do is a reminder to that it empowers people. Partners in particular who are sort of wondering, is this my job to challenge this? Can I just sort of fade into the background and I just didn't see it? The answer is yes, it's your responsibility. And also, if you don't do anything about it, firstly, people see that. So that the person who's actually on the receiving end of the treatment usually knows who saw it or that people are aware of it, and they will say X knew and never did anything. And that presumably is a risk for the person who didn't do anything. And I guess what is that risk?
Yeah, so the guidance makes clear that they will take action against individuals that repeatedly fail to challenge behaviour. So you could be sort of a witness to something you haven't actually behaved unfairly or done anything yourself, but you could still find yourself in the SRA's crosshairs if you haven't reported something over a period of time, you haven't challenged something that you should have done.
Mhm.
So it does say repeatedly failing to challenge, but you could also see a scenario if it was a really egregious incident and someone failed to challenge it or report it, that even that in itself might be enough. And
Right.
of course, you've got sitting alongside the obligation to challenge is the obligation to self-report potentially serious breaches of the rules as well. So it might be behaviour which isn't serious enough to be reportable, but it should still be challenged.
Mm.
Or it might be both. It should be challenged in the moment and reported to the court because it's a serious breach of the regulatory arrangements.
In practice, how seriously do we see the SRA taking, and how far do we see them taking the notifications that are made, whether it's sexual misconduct, whether it's bullying or other forms of unfair treatment, to the extent that those are sort of feeding through the system? I mean, how proportionate are they being? Are they being in their response to these notifications, and which ones they take forward, and which ones they say, okay, the firm's done what it needed to do, nothing to see here, etc. What's your sense so far?
What we're seeing is that whenever sort of any allegation of non-financial misconduct, sexual misconduct, bullying, etc., is made, the SRA are typically asking firms to show them their policies, to tell them when they last had training, to say whether there's been complaints made about the individual that's been reported before and whether they were dealt with. So they are asking questions of firms.
Mm-hmm.
And usually firms are in a position to answer those questions, then it will usually end there, and then the focus will shift onto the individual.
And we've definitely seen that, right? That the firm
Mm.
is kind of, okay, you did a good job of dealing with the situation. You know, the focus then is mainly on the individual. Yeah.
Yeah, so that's obviously the gold standard is it doesn't happen at all. But if it does happen, at least being able to say, no, this person had the training, the policies were very clear, no prior incidents, or there were prior incidents and they were dealt with appropriately at the time.
Mm-hmm.
And in terms of the SRA's approach to individuals, yeah, I mean, obviously the sexual misconduct cases are still going through, but in terms of bullying and harassment, we haven't seen that many, apart from a sort of a very serious example of bullying where someone was shouting in people's faces and kicking chairs, and really sort of extreme behaviour. That
Mm-hmm.
individual was struck off the roll a couple of years ago. But the more sort of perhaps nuanced allegations, so some of the ones that we've spoken about in this talk, we haven't really seen any of those come through. They sort of remain sort of hypothetical cases in the case studies at this stage.
Because they're still being considered by the SRA as part of its big old backlog.
Yeah, exactly. It can take such a long time for them to come through, and I don't know. I mean, they talk in these cases about how it may be misconduct under the rules, but whether or not they would take a case like that forward, for example, the state school
Mm.
solicitor not being selected for client cases, whether they would consider that serious enough to actually bring action against a firm or an individual, I'm not sure. I think time will tell in that
Mm.
regard.
And they do have a number of other fish to fry right now, right? With AML being spun out of the FCA and the fallout from Axiom Inc. and all those issues. So
Yeah, I
maybe
agree.
they're picking their battles, right?
I agree, and because they did go in to a number of relationship manager firms, so the larger firms that have relationship managers in late 23, early 24, and they were asking firms how many complaints have you had and how have you dealt with those complaints, and can we see the non-disclosure agreements if any were entered into, and asking them how do they sort of what their training is like, and they're asking all those questions. And the feeling was that the answers to those questions were going to lead to a thematic review for some
Mhm.
further guidance about best practice, etc. But that has never materialized. And I think that is probably because, as you say, they've been fighting a number of other battles in the last sort of 12 months. And maybe we haven't seen as much from them in this regard as a result, although we did get this updated EDI guidance in September.
Yeah, which was just kind of was quietly slipped out, kind of out into the public domain. And I did wonder whether, in a world which is slightly focusing less on diversity, equality, and inclusion in this sort of Trump world, whether it had less of a fanfare as a result of that. I do think it's a really important thing, and we will come back to it in another episode of this discussion. But are there any final tips for law firm HR professionals that you would suggest, kind of just pulling aspects out from our conversation today?
I think refresher training, if it hasn't been done, would still be useful. I mean, it's been 2.5 years now since the rules have come in, and it may be something that people are still updating on annually, but perhaps this revised guidance from September would be a sort of a prompt to do that.
Yeah,
Because as
I'll
I
read the guidance definitely as well.
Yeah, as I say, I think that it has perhaps slipped down the agenda, certainly from the SRA side, but I think firms still need to be very much aware of it and keeping that up, because I know there was a lot of good things done when the rules came in, and I don't know whether that's continued or whether it's almost been like, okay, these rules have come in, this is what we have to do. We've done our training, we've done some good stuff around amending our policies in terms of making them consistent with the requirements challenge. But I don't know how much follow-up there has been at a firm level on that, and whether that's sort of being repeated or whether it's just sort of slotted into their sort of annual refresher training.
Right. So, I mean, things that will be very familiar to HR is creating the speak up culture, ensuring you've got the policies, ensuring the training's up to date, ensuring that you're monitoring compliance where issues arise, actually dealing with them effectively, and obviously doing the appropriate remedial work when there have been issues, and also making sure that this cascades down from the top. So it's the leadership, the partners are really walking the talk on these issues as well. So all of these are really this is natural stuff to be within the remit of HR, and it's just ensuring that they feel comfortable with the SRA obligation to sort of overlay what they're doing already within the employment law world. So thank you so much, Andrew. And thank you. If you stayed with us to the end, we really appreciate it. We hope we've enjoyed it. Do get in touch if you ever have any sort of queries where you just want a little informal chat or sense check. We're always very happy to speak. And Andrew and our other SRA regulatory partner, Nick Lee, will be very pleased to speak with you. So hope you've enjoyed it. Do check out some of the documents the guidance that Andrew has suggested, and hopefully see you again soon for the next edition of this SRA for HR. Thanks. And thanks again, Andrew. Cheers. Bye.